What is a statutory summary suspension? I'm an Illinois attorney, and this is a longer explanation of what it is. I also have a 1-minute video explaining it, but here's the long version. Specifically, when you get a DUI case, you get two cases. The first case is from the county that you received the DUI. Say it's Cook County, Kane County, Ogle County, wherever you got the DUI. You get DUI tickets. And you're presumed innocent until proven guilty. And the reason you're presumed innocent until proven guilty is because it's a criminal case. So they don't do anything to you on this DUI case until down the road. However, the second type of case you get is a statutory summary suspension. That isn't from the county, it's from the Secretary of State. The Secretary of State is the entity that gives you the right to drive. When you went to go get your driver's license initially, you went to the Department of Motor Vehicles, which is a department of, or a division of, the Illinois Secretary of State. And it's called an implied consent suspension, which means that if you drive a car and a police officer thinks that you're intoxicated, you agree to give a breathalyzer. And if you give a breathalyzer and you're over the legal limit, you agree that your license will be suspended for a certain period of time. If you refuse to give a breathalyzer, you also then agree that you would have a longer suspension. The mere fact that you have an Illinois driver's license, you already agreed to all these provisions. You never signed anything, but it's all implicit in having an Illinois driver's license. Now, first of all, when does a suspension take effect? Some suspensions could take effect immediately, and that's if there's an accident where there's a death or severe type A, they call it type A, personal injury, and that's severe bodily injury. But provided that doesn't happen and you just got pulled over and were given a DUI ticket, the suspension will take effect 46 days from the day of your arrest. Now, your court date may happen before 46 days, or your court date may happen after the 46, or it could be on the 46. But your court date is completely independent of the date that your license is going to be suspended. Now, you also have the option to fight the statutory summary suspension. Now, I fight a lot of these statutory summary suspensions. In order to fight it, you need to file a document with the court. You would file it with you don't file it with the Secretary of State, you file it with the county where your DUI is. And what you file is called a petition to rescind the statutory summary suspension. Once that's filed, they have to give you a hearing to determine whether that statutory summary suspension is not going to take effect. And they have to give you that hearing within 30 days or the first court date, whichever is later. So once that petition to rescind is filed, you are not entitled to go before a judge and ask that the suspension be thrown out for 30 days. And again, or the first court date, whichever is later. So if you file it and the first court date's 40 days away, you're not entitled to a hearing until 40 days. If your suspension is scheduled to take effect before you're entitled to your hearing, then you're going to lose your driver's license for a period of time. Why would they throw out the statutory summary suspension? There's 5 reasons why you can have one thrown out. I won't go into great detail about it, but one of the reasons, for example, is if the police officer did not read the warning to motorists to you. The warning to motorists is part of the statutory summary suspension paperwork that explains to you that you could be suspended and what would happen if you gave a breathalyzer or didn't. So if the officer didn't read that to you and you have a hearing and the judge believes the officer didn't read it to you, he could throw out that statutory summary suspension. Likewise, I have a lot of statutory summary suspensions thrown out because the judge watches the video, or I question the police officer and the judge goes, I don't think you had a reason to arrest him for DUI. And you could have the suspension thrown out for that reason. Now, once a suspension takes effect, or I should say, once you are issued a statutory summary suspension in Illinois, they will give you the option to drive during that suspension period, provided you put a BAID machine in your car. A BAID machine is a breath alcohol ignition device. So they actually install a machine in your car. You have to pay for it. And before you start your car, you have to blow into this machine. And if it detects alcohol, it will not start your car. And as you drive, it will beep. And you have to, as you're driving down the road, you have to breathe into this machine, this straw, whatever apparatus they have, and constantly give breath samples to make sure that, you don't have your friends start your car for you or something of that nature. And the machine also has a camera on it, so it's recording who's doing this. But the important thing about the BAID device is if you don't want to be suspended and you need to file a petition to rescind the statutory summary suspension, and you also have to apply for the BAID device as Plan B. Obviously, Plan A is get the suspension thrown out, right? So you can just drive your car like normal. But Plan B would be to have the machine in your car. Having the machine in your car and doing that, not a very good solution, but it's better than not driving at all. Or driving your car when you don't have a license, because that is a whole nother host of problems. Now, after the statutory summary suspension, there's a reinstatement fee. The reinstatement fee currently is between $250 and $500. If you've never had a statutory summary suspension before, it's $250. If you had a prior statutory summary suspension, even 20 years ago, it's a $500 fee. If your license is coming back on a certain day, which the suspension will be over on a certain day, you're not allowed to drive after that day until you pay the reinstatement fee. The Secretary of State wants their money, and you don't have a valid license until you pay that money. You should pay the statutory summary suspension fee as soon as you can after you realize that you're not going to have the statutory summary suspension rescinded. So for example, if you send them $250 and then your attorney gets the suspension removed, they're not sending you that $250 back. So don't send the $250 until you know that indeed you are going to be suspended and the attorney's not going to be able to have the statutory summary suspension rescinded. If you have any other questions, feel free to call me. My information follows this video. Thank you.